Let's go back on the record. Good morning. Today is October 8th at 9 a.m. Again, we are continuing the hearing that is titled In the Matter of the Application of Confluence Rivers Utility Operating Company, Inc. for authority to acquire certain water and sewer assets and for a certificate of convenience and necessity. This is file number WA-2019-0299, which has also been consolidated with file number SA-2019-0300. Again, my name is Charles Hatcher, and I am the regulatory law judge presiding over this hearing. We've had everybody make their entries of appearance yesterday, and we have an outstanding request from Confluence Rivers. Confluence Rivers, would you restate your request one more time? Just to make sure that I have it correct.
I'll see if I can do that.
Let me try it this way. You want to recall one of your witnesses, Mr. Thomas or Mr. Cox, to introduce pictures that they took 5 days ago.
Correct. In response to the new testimony that was offered yesterday by the Lot Owners Association.
Tell me how that was new.
Well, the commission's order, of course, ruling on the motions to strike certain survey testimony from the company's testimony, found that the surrebuttal was appropriate and in accordance with the commission's rules, but provided the association the opportunity to provide live responsive testimony to that surrebuttal during this hearing. I think our position is that it's been stated before that the applicant has the burden in these cases. I think the commission's rules are set up to acknowledge that through the fact that normally in the testimony process, the applicant gets sort of the last word with surrebuttal. And so I think in this situation, given the new live testimony that was provided yesterday, that the company would like the opportunity to respond to that in kind.
The pictures that he was referencing wasn't new testimony, though, correct? It was already an addendum to pre-file testimony. The sealed and the unsealed engineering reports, are those the pictures that you're referencing as being new?
No,
okay.
No, it was Mr. Sayers' testimony as to the condition of the system in regard to
that he had seen
violation, yes, violations of or non-violations in his testimony, I guess is the way he said it was completely in compliance with permit and design standards, and so it's that testimony that we would like to respond to.
Can you tell me, you've had the pictures for 5 days, why they weren't introduced earlier?
I don't think we had the opportunity to introduce anything earlier. Testimony was filed quite some time, well, some time ago.
Mr. Linton, could you please rephrase your objections again?
Yes, and I guess there's some confusion about pictures. We did not introduce any pictures. But to back up and give you the context for the situation is during surrebuttal testimony, Confluence Rivers introduced new testimony that should have been in their direct testimony, their case in chief. I requested a motion to strike that new information because it was new information and should have been included in the case in chief. I asked for, in lieu of that, more time to do some discovery to be able to cross-examine the witnesses on that new information. Your order said, no, I won't strike, and I won't give more time for for discovery, but I will allow you to introduce evidence in response thereto with your witnesses. I carefully followed your order in limiting my questions to the prior surrebuttal testimony. The new surrebuttal testimony that you identified was appropriate for additional information. And the pictures, I think, that we're talking about were the pictures that were in that surrebuttal testimony and part of the surrebuttal testimony that that was appropriate to respond to. So I carefully limited my questions to that part of the surrebuttal testimony. If we're now going to introduce more new testimony in the form of pictures, I guess I would ask, limit that and give me time to do some discovery on that as well.
I have been very conflicted about this decision because the first thought in my mind was we have new information, and the commission needs information. The commissioners need information in order to make their best informed decision. So how could I keep information from the commissioners? But I am very aware of Mr. Linton's claimed issue with allowing more new testimony. He's going to be prejudiced. He's going to have to be allowed to do his own investigation on this. And he's quite right in the order trying to make sure that the playing field is level, giving him and all parties extra time during live testimony.
Judge,
Yes.
and that's the problem. I think we're in the same problem, or in the same place that you just described for Mr. Linton. I mean, it's sort of the commission generally has wanted to avoid sort of litigation by surprise, and that's the reason for the pre-filed testimony. And it's difficult as soon as we start to branch out into live testimony like this for everyone. I mean, we're sort of in the same situation. We had to react yesterday to live testimony that we heard for the first time yesterday. So, again, I think the problem you describe is true for us as well.
I'm going to sustain the objection. We have two witnesses for today. We have Carrie Roth, and we have Mr. DeWilde. OPC, Public Counsel, you were in order coming up first yesterday. Did you want to go ahead and call Ms. Roth first?
I have no preference. I will defer to the commission's decision.
Let's go ahead and take Ms. Roth first.
Absolutely. Why? Yeah, let me grab. Let me move.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. Please be seated. Public Counsel, go ahead.
Thank you, Your Honor. Ms. Roth, can you please state and spell your last name for the court reporter? Oh, sorry, state your full name and spell your last name for the court reporter.
Carrie Roth, K-E-R-I, last name Roth, R-O-T-H.
And by who are you employed and in what capacity?
I am employed by the Missouri Office of the Public Counsel as a public utility accountant.
And have you prepared or caused to be prepared certain testimony that has been pre-marked in this hearing as Exhibit 300, P and C?
200?
200, you're right.
Yes.
I apologize. If I were to ask you the same questions that were asked of you in those testimony, would your answers today be the same or substantially the same?
I do
Actually-
have one correction.
Yeah, I was going to, sorry, getting ahead of myself. Do you have any corrections to make to that testimony?
I do.
All right, what was that correction?
On page 9, line 1, It says association witness Mr. Sayer. It should be Mr. Justice to match the footnote down below. I believe that's all I have for corrections.
All right. Notwithstanding that one correction, if I were to ask you the same questions that were asked of you in that testimony, would your answer today be the same or substantially the same?
Yes.
All right. And those answers are true and correct to the best of your knowledge and belief?
Yes.
In that case, I offer OPC Exhibits 200, P and C, and tender the witness for cross.
Thank you. Do we have any objections to the admission of Exhibit 200?
Yes, Your Honor, we've got some objections to primarily some schedules, and I've got a list of those I'll provide to the parties and to you. I think it'll make it simpler to go through. So.
Okay.
Judge, we have an objection also. Yesterday, Mr. Francis withdrew, or OPC withdrew Mr. Francis's testimony, and to the extent that Ms. Roth is responding to Mr. Francis' testimony, we're going to ask for it to be redacted. I can give you the pages and line numbers.
Mr. Kleiser, on staff's objection first.
A witness can rely on hearsay evidence for the development of her own opinions. The fact that Mr. Francis's testimony was withdrawn does not mean it was filed. She used it to develop her testimony. She should be able to rely on those statements for the development of her opinion.
It simply doesn't make sense for her to be referring to testimony that hasn't been entered into evidence, and so it should be redacted. It should be withdrawn.
Mr. Linton?
I agree with Mr. Kleiser that Mr. Francis did file testimony. It was supported by affidavit. It is evidence. While the commission cannot take that evidence into account in this case, I think Ms. Ross may, in that she can take statements by others informing her opinion.
Confluence Rivers, do you want to weigh in?
Well,
on staff's objection?
yeah, well, certainly we think staff's objection is appropriate. And as we get into our objections, at least one of ours is going to be similar to that, I think. So.
I will point out, Your Honor, that the same objection was raised in the Osage case and was permitted to stay in. Confluence attempted, well, not Confluence, I apologize. Osage Utility Operating Company objected to the inclusion of testimony that cited to statements made by Great Southern Bank, I believe, and it was permitted, included.
Then I feel in good company. Objection overruled. Your testimony can come in without any redactions relevant to Mr. Francis's testimony. On to Confluence Rivers objections.
Yes, Your Honor. First one would be as to Schedule KNR-2, which is a photocopies of several what purports to be petitions. Ms. Roth doesn't claim to have collected those or overseen the process, nor can verify the accuracy, and it just seems like those sort of non-testimonial expressions of members of the public are more appropriate in the comment file for the case than they are in evidence.
I'm going to check to see if they are already in the comment section. I believe that they are. If they are, staff, could you help me out? I took the sheets that were provided at the local public hearing, the same sheets that are being objected to currently, and had them submitted, I believe, as public comments?
Yes, they were entered into the public comments.
Okay, so then the commission already has access to those. So, Mr. Cooper, it seems to be your choice if you want me to strike those or not, because they're already entered as public comments.
I think they should be stricken from the testimony. Yes.
All right?
Just for clarification, being entered into the public comments, are they part of the evidentiary record? Can they be cited to, the existence of these comments be cited to?
I believe historically the commission has treated public comments as informing the commission of the public's view, but not as citable evidence. Go ahead.
Okay, well, again, the OPC's position in this case is that the interest of the public requires an examination of the actual expressed desire and interest of the public. Therefore, we are citing to this comments as evidence of that effect. I mean, if the commission just wants to take administrative notice of its own comment section such that it can be cited to as part of the evidentiary record, then I don't see a problem with not including it as a schedule. The point is I just want to be able to cite to the comments themselves, as I believe that that is an exceptionally relevant point in this case.
I don't think those comment sections ever been viewed as evidence. There's just no foundation for them.
But Mr. Kleiser is correct. This does weigh in the commission's decision, and just the fact of the collection of signatures he's wanting to cite, and I think that should be citable. So I am going to overrule your first objection for page 4, line 5, KNR, schedule KNR-2.
The second item on there concerns KNR-3, and which is 2 pages of a hearing script or hearing transcript from an evidentiary hearing of an unknown date. There's no representation on the pages, and we would argue that there's no relevance to the case. There's no evidence that the financing arrangement described reflects or represents current financing plans. And in fact, testimony yesterday indicated that it does not.
Sorry, I'm still getting to KNR-3. Okay, KNR-3, I'm seeing it just begins mid-transcript, it appears, and the caption, which appears at the top of the page, this is a question, Mr. Cooper, does it say, in the matter of the water rate increase request of Hillcrest Utility Operating Company?
It does indeed.
Okay.
Your Honor, a little bit more information is also found in the addressing footnote 2. Page 4, footnote 6. It is case WR-2016-0064. Hearing transcript, volume 2, pages 113, lines 23 through 25, that Ms. Roth is specifically citing to. These documents are part of a commission record in a different case, and she's just citing to them to support the position or statement that she's made in her testimony that Confluence has been unable to find traditional bank financing in the past, which goes directly towards the question of Confluence's financial abilities in this case. Now, I understand the argument that Mr. Cooper has made, but that goes to the weight of the evidence. It is still relevant that they have been unable to find traditional bank financing in the past.
How is that relevant if they've promised, or if they've stated that they're going to buy the utility with cash or equity?
It goes to the general state of Confluence's overall financial capabilities. Again, the commission is free to consider the weight of that evidence, and it may determine that there is very little weight to that evidence. But as to a question of relevance, it's simply just, is this more or less likely to address the issue of Confluence's financial ability? And I would argue that, yes, it clearly addresses that issue.
Mr. Linton, would you like to weigh in?
I have nothing to add. I think Mr. Kleiser has made a good point, and I support his position.
Staff would like to weigh in?
Staff agrees with confluence for all the reasons stated.
I do as well. That was from a previous case. The request by confluence to strike, I want to state this correctly, Mr. Cooper, Schedule KNR 3 and page 4, footnote 6.
Correct.
It is so ordered to strike that. Your next objection, Mr. Cooper?
Yes, concerns Schedule KNR-4, which is a copy of an OPC brief before the Court of Appeals in an appeal, WD 81661. We certainly would say that a brief is argument. It should not be evidence in a case.
I don't want to cut off Mr. Cooper here, but I'm actually going to say I'll withdraw that schedule.
Okay, problem solved. KNR 4 and page 4, footnote 7 are struck from Ms. Roth's testimony. And
Oh, the
Yes.
whole page?
I hope I did not say that. I mean page 4, footnote 7.
Oh, okay.
And just footnote 7 on page 4 and schedule KNR-4.
All right.
You weren't withdrawing the whole page, John?
Good catch, thank you. Okay, Mr. Cooper, on to your next request.
Okay, so Schedule KNR 5, which is, again, it's similar to our earlier situation. It's a excerpt from a prior hearing transcript, again, without any evidence that it reflects or represents financing plans for Confluence Rivers.
Well, at the risk of being overturned again, I would raise the exact same argument I did previously. She is citing to this to support the statement made in her testimony, and it is record that has been included in past cases, and I see no reason why she should not be able to cite to it to show that what she's saying is accurate.
Can you point me to the line on Schedule KNR 5 that's at issue, or lines?
According to the footnote, it would be lines 1 through 6 of page 426.
Okay, and this is from a case from 2 years ago. Can you briefly summarize why it's relevant?
Well, the statement made in the testimony that's being supported is that the owners of CSWR have never been willing to put up personal collateral to secure traditional bank financing.
And Your Honor, there's been testimony that the owners identified there are not the owners of the company today.
I have a problem with the partial transcript and a problem with it being from another case from a couple years ago. I find that hard to bootstrap that relevance. I'm sorry, I'm going to sustain Mr. Cooper's objection and strike Schedule KNR 5 and footnote 8 on page 4.
Would the commission be willing to just take administrative notice of the entire transcript from that case? I mean, the transcript speaks for itself. Again, they're more than willing to argue what they want about it, but it's just commission records.
To summarize, you want to put evidence from several years ago that the then owners of one or more of these utilities either weren't willing to put their personal assets up or otherwise had some type of financial difficulty.
I would argue that goes to the determination of Confluent's ability to meet the financing criteria. Again, others might disagree with that, and the commission can interpret the weight of that evidence through the briefs. I'm just asking for the evidence to be presented. And this is, as I said before, commission records.
We're still on the fourth request by Mr. Cooper.
We're on
which
page
begins-
4, footnote 8, I believe.
Okay.
Let somebody correct me. That's what I thought.
I'm sorry, I'm going to sustain Mr. Cooper's objection. If I did not already state, then Schedule KNR-5 and footnote 8 of page 4 of Ms. Roth's surrebuttal testimony is struck.
Judge, the last item has to do with a piece of pre-filed testimony that was offered in a different case, WA-2019-0185. It was not admitted into evidence into that case because the witness was not there to stand cross-examination. And now it's being offered, I assume, as evidence as a schedule to Ms. Roth's testimony in a different case, in this case, along with, as you can see, it really, there's probably, yeah, along with lines 1 through 16 on page 9 of the testimony. We just don't believe that again, testimony from a different case, testimony that was never admitted into evidence in that case, should now be evidence in this case without the witness appearing.
Excuse me. Once again, I'd start off by simply saying that Ms. Roth was free to make her determination or form her opinion based on the testimony that's been offered. And as for, we're not actually offering it to prove the truth of the matter asserted either. We are merely offering it to show that there's a similarity of behavior that's been exhibited across multiple cases. Well, I can't cite to specific case law. I believe that is a general recognized exception to the hearsay rule, at least as far as, well, I'm fairly certain it is in at least criminal cases, a kind of pattern of behavior. I can't say that I've seen that extended to civil cases necessarily.
But whether that is or isn't the case, what we have here is not testimony from the prior case.
Would staff like to weigh in?
Well, we believe that Mr. Francis' testimony, or the referrals to Mr. Francis should be admitted, and we agree with Confluence that we have no opportunity to cross-examine Mr. Sokonik. Should be taken out too.
Mr. Linton?
Yeah, this objection strikes me as very similar to staff's prior objection regarding Mr. Francis, and in which the judge overruled the objection. Ms. Roth is capable of using testimony that apparently has an affidavit with it as supporting her opinion.
Judge, if I might add, Mr. Sokonik's testimony is in a different case, and it seems perhaps that it's more similar to your rulings on the other two, the transcript rulings.
I would have to agree. We have rules, just as I was talking with Mr. Cooper earlier on his request to bring back Mr. Cox. We have rules setting out all of this testimony, pre-filed and rebuttal, in order to try and get as much information to the commissioners as possible, but in an orderly manner. I'm going to have to sustain Mr. Cooper's objection and strike Schedule KNR-8, as well as lines 1 through 16 of page 9 of Ms. Roth's surrebuttal testimony. Okay. I think we are now back to the original question. With staff's and Confluence River's 5 objections handled, does anyone have any other objections to the admission of Exhibit 200, both public and confidential versions? Okay. As so amended. Seeing no objections, as so amended, it is admitted onto the hearing record. Mr. Kleiser, witness is yours.
I believe I already tendered the witness across, but just in case, I tender the witness across.
My mistake then. Cross, we are continuing with the pre-agreed to order, and we will turn first to the Lake Perry lot owners. Mr.
I have no questions, Your Honor.
And staff.
Good morning, Ms. Roth.
Good morning.
Thanks. Would you please describe OPC's investigation of the Confluence application?
Can you be more specific?
Well, let's just speak generally. What was your process in writing your SIR rebuttal testimony?
My SIR rebuttal testimony is in response to the rebuttal testimony of the association witnesses.
Who did you speak with?
In regards to,
In preparation of your SIR rebuttal testimony, did you speak with anybody?
specifically
Speak with anybody at Confluence
at Confluence? Mm-hmm. About
about the systems?
association testimony?
Yes.
No.
Did you speak with Mr. Francis?
No.
Did you speak with Mr. Justice?
No.
Mr. DeWilde?
No.
Mr. Sayer?
No.
Mr. Cox? Mr. Thomas?
No.
Did you speak with anybody on staff?
No.
Did you visit the site?
No.
Did you attend the local public hearing in Perryville?
I did.
You were there?
Mm-hmm.
Okay. What kind of investigation did you do of the lot owner's proposal?
I just read through what they had filed.
Did you do any investigation of the Confluence application?
I've just read what's been filed in testimony.
Are you familiar with the term desk review?
No,
You've never heard that term?
I have not. Sorry.
Okay. If I represented that means that you relied totally on previous research, there was no independent data collection or investigation of your own, does that sound like a reasonable definition of it, considering what the term is?
I wrote my testimony based on what has been filed in the case. And that's what I reviewed.
So you did no independent investigation?
I did my own reading. I think that's independent, and my own analysis based on what I read.
Okay. In making your recommendation, did you consider the property rights of the owners?
Can you clarify what you mean by that?
Well, the owners, sellers of the systems clearly have property rights in their utilities, wouldn't you say?
State that one more time. I'm sorry.
The sellers of the utilities, they have property rights in their systems?
Correct.
So what would you say those property rights include?
Are you asking me if they have the right to sell their system?
I guess in a roundabout way.
I believe that they do, yes.
So did you consider that right when you were preparing your testimony?
Yes, but it's also been stated, I think, that if the sale does not go through, they don't have to sell. They will continue operating the system based on some statements and a motion to strike at the town hall meeting that was held.
What consideration did you give of the property owners' rights to sell the system?
I don't know what you mean by that question.
Well, did you weigh it against other aspects like the local control issue or the financing issue?
I think it's very important that the Lot Owners Association has done a tremendous amount of work and have shown interest in also purchasing. Whether they succeed in that, if this does not go through, is another story, but I just think that that's something that should be considered.
The lot owners you're talking about, their
Yes.
interests should be considered? And the property rights of the seller should be considered too? Okay.
Yes.
To you, what is the purpose of the not detrimental to the public interest standard? What does that mean to you?
Not detrimental. If there's a cheaper option available, or clearly the public has stated that they do not want Confluence to purchase the system, I think that's right there stands up to that.
So to you, cheaper means better?
No, not necessarily, but I think that they've shown that they're very capable. They have individuals who currently help out with the current owners. So,
But you're aware that the lot owners do not have a contract to purchase the system?
they have submitted an offer, but no, I don't believe there's a signed contract between the parties, no.
Okay. Would you agree that the purpose of that standard, I'm speaking of the not detrimental to the public interest standard, is to ensure the continuation of adequate service to the public?
Yes, and I think the lot owners have shown that they could probably do that too.
Do you believe that Confluence doesn't have the ability to run the systems?
I think that they do have the ability, but I think the public has stated what they want.
So that's the overriding concern for you, is what the public has stated?
I think that they have stated that. They have put a tremendous amount of work together to show a business plan and what their intentions are. I think that they will be capable of running it themselves.
Were you involved in a prior case with Confluence? It's case number WA-2019-0116, which involved the transfer of about 9 CCNs to Confluence?
I reviewed stuff on that case, yes.
Okay. Did you provide testimony in that case?
That's what I'm trying to remember. I don't think that I did on that case.
But you're aware of the case generally?
Yes.
And you're aware that OPC entered into a stipulation in that case? And you're aware that in that case, OPC basically stated that Confluence has the TMF, the technical, managerial, and financial facilities to operate these systems?
Yes, but none of those systems also had other interested parties, I don't believe, in purchasing them and who have intervened in the case, such as the lot owners in this case.
And so you believe that the lot owners intervening in this case makes it a different situation, and that their voice should be heard?
I do.
One moment, please. That's all I have. So is it OPC's position that if another interested party is interested in purchasing the systems and is going to pay probably less than the contracted price, that the commission should award the system to the other? I'm stating this very. let me start over on that.
Sure.
So is it OPC's position that if another interested party, other than the applicant, is interested in the systems and is offering less than the applicant, that the commission should consider awarding CCNs to the other party, not the applicant?
I think that all parties should be considered and reviewed, not just, even if it is just a lower offer. I think that everyone should be considered. I think that's fair, and it is in the public interest. That's the whole standard, and the public wants to purchase the systems.
That's all we have. Thank you.
Thank you. And Confluence Rivers?
Thank you, Your Honor. Ms. Roth, in your testimony, you describe the bank financing commitment that you believe that the association or the Lake Perry Service Company has to be at a possible fixed rate of 3.65 or 4.45, correct?
Yes, that's what I restated based on the letter.
And what you're referring to then, again, based upon the letter, is a $300,000 loan that would be secured by a $300,000 CD that would be placed with the same bank, correct?
Just Where exactly in her testimony, just so I can follow along?
Sure. It's Sir Rebuttal, page 4, lines 6 to 11.
Thank you. I'm sorry for interrupting.
Sorry, can you repeat your question?
Sure. And do you have that testimony in front of you?
I do.
So in lines 7 through 11, you talk about First State Community Bank provided a commitment letter on May 3rd of 2019. And by the way, I take it you looked at that commitment letter, right?
I did look at that, yes.
And it was a commitment for 60 days, is that correct?
Subject to check. I am not positive on that.
But the letter's in evidence already, isn't it? It's attached
I
to
believe
other
it is.
testimony.
Yeah.
So while we're there, so you're talking about a $300,000 loan that's secured by a $300,000 certificate of deposit that would be placed at the same bank, correct? And then you say fixed interest rates of 3.65 and 4.45% were provided by the bank at the time of the letter, correct?
Correct.
Okay. Now, would you agree with me that in order to get the money for the CD, the Lake Perry Service Company is promising to pay interest to their investors, correct?
I believe that's correct.
And Mr. Justice says that the average rate of return to be paid to those investors is about 7.5%, correct?
Can you point me to where that is?
I can. You have his testimony there with you?
I do.
Okay.
You're referencing the justice testimony?
This will be the justice testimony, rebuttal testimony, page 10, lines 7 to 8.
Yes, that's what he states.
So in order to get this loan, the Lake Perry Service Company is not only going to pay interest to the bank, the 3.65 or 4.45 that you mentioned, but they're also going to pay about 7.5% to the investors that provide the CD dollars, correct?
And I also believe it states that they expect a CD to produce a return of 2.5%.
Correct. So that'll offset a little bit,
Correct.
right? But ultimately, would you agree with Mr. Justice that the effective interest rate for that $300,000 loan is 8.65%?
Considering the percentages that we just discussed, yes.
Okay. And to get to 8.65, you have to take into account the return on the CD, correct, as you just mentioned?
Correct.
Otherwise, the interest rate would be something over 10,
Right.
correct? Now, it was kind of mentioned in our earlier discussions about the objections, but you indicate that the owners of CSWR have never been willing to put up personal collateral to secure bank financing, correct?
That was what I had in testimony. Yes.
And is it your understanding that under the current ownership, Confluence River's owners have utilized equity to make the purchases of the 9 water and 9 sewer systems that the company currently owns?
That's my understanding.
And is it your understanding that Confluence Rivers plans to purchase the assets of Port Perry using equity as well?
That's my understanding.
And within the commission rate-making process, is there any guaranteed return on equity?
State that one more time.
Within the Public Service Commission rate-making process, is there ever a guaranteed return on equity provided by the commission?
No guarantee.
Right. So within the case, we may set a target amount for equity, but ultimately, whether the shareholders earn that or not depends upon events, correct?
I think that's fair, yes.
And they don't have an opportunity to go back and collect more if they have a lower return on equity in practice than was targeted in the case, correct?
Correct.
Now, in talking about past financing, you also recount some past rate cases and interest rates, I believe, within your testimony itself. And the last case for a CSWR affiliate was the Indian Hills rate case, correct?
Can you flip me back to my testimony,
Sure.
please? Page 4 and 5.
Correct.
Yes, the last one that I discuss is Indian Hills.
And I believe you state in your testimony that the company's proposal was rejected by the commission, correct?
Correct.
And would you agree with me that in place of the company's proposal, what the commission used was an interest rate of 6%?
I have 6.75 in my footnote.
Okay. We'll go with that.
Okay.
Now, in terms of rates for past affiliates, or affiliates of CSWR, did you compare the amount of investment in those rate cases per customer as to the amount of investment or repairs that are being estimated by the company in this case per customer?
I haven't compared that, no.
And if you were going to look at or project rates, that would be important to know, wouldn't it?
Yes.
Now, and I think you said this already, you acknowledge that the Lake Perry Service Company has no contract to purchase the Port Perry assets today, correct?
No, I don't believe there's a signed contract.
And maybe you got to this with the staff questions, but you haven't inspected yourself the Port Perry water and sewer facilities, have you?
I did not go on site and look at the facilities, no.
So you personally don't have an opinion as to the current condition of those facilities, correct?
No, it's my understanding they're in compliance from what I've read.
Now, again, in your testimony, I believe you expressed an opinion that a purchase price greater than the net original cost might be detrimental to the public interest, correct?
Can you point me to my testimony?
Yeah, pages 5 and 6.
Yes, I state that I was concerned with the purchase price being excessive compared to staff's rate base.
Right. Now, it's not uncommon for purchases of utility assets to be at prices greater than net original cost, is it?
No.
And you would agree with me that ultimately in a rate case, the rate base would likely be set at a net original cost amount?
Yes.
And there's no proposal in this case to do anything different, correct?
Correct.
So there's no proposal under the new non-viable utility rule to do anything other than net original cost, correct?
Not under the non-viable utility rule, no.
Okay. Are you familiar with any rate case in the past where recovery of an acquisition premium was allowed by the commission?
Not off the top of my head.
So ultimately, regardless of the purchase price, it's likely that the net original cost would be used in a future rate case, correct? To set rates?
It's possible.
Just possible?
Can
Not
you
at least likely?
restate your question for me, please?
Would you agree that it's at least likely that in a future rate case that the net original cost would be used for the purpose of setting rates as opposed to the purchase price?
Typically, in the past, that's been staff's position, and as I stated here, my concern was that staff had not made a recommendation at the time that I had wrote my testimony. So that was my major concern with the purchase price being so high over that the utility could come back in a future rate case and request an acquisition premium, not necessarily to the non-viable utility standard statute.
Now, let's see. You also state in your testimony, I think this is on page 8, that the Port Perry water and sewer systems do need improvements, but if they were purchased by the association or the Lake Perry Service Company, they would be done at a much lower cost. Is that correct?
That's what the association has indicated, is my understanding, yes.
But and I don't believe you were here late in the afternoon, but I think Mr. Sayer acknowledged that his report projects the possibility of $670,000 of improvements. Is that consistent with your understanding from his testimony?
Can you point me to his testimony?
I'm not sure that I can. Let's start with this. In making your statement, what amount of improvements did you think were being proposed or estimated by the Lake Perry Service Company?
My understanding is that they have the initial money set aside for the initial improvements. I'm not sure if that's an HC number, so I don't want to
That's okay.
state the dollar amount, but within 5 years, they had planned to invest more money, which considered larger dollar amounts in the business plan.
Right. Do you have Mr. Sayer's testimony in front of you?
I do.
While she's getting there, Judge, for the sake of the record, and is anything in Sayer's report confidential?
Nothing.
Nothing in the Sayer report is confidential, just in case that helps answer.
Thank you.
If you'll turn to, let's see, Schedule CWS 1 in that testimony.
You said CWS1? Mm-hmm. Okay.
And then a few pages back, you'll see preliminary engineering report summary.
I did not print that copy.
Okay.
I didn't print the full schedule, I don't believe. Sorry.
May I approach the witness, Your Honor?
Yes.
Thank you.
Mr. Cooper, remind me which schedule we're on?
You're on CWS 1, and within that, the preliminary report. And do you have before you the page that starts with 4.0 estimates of probable costs and timing?
I do.
And you'll see down there estimates numbers, right? 30,000, 450, 100, 10,000, 30,000. And then if you flip that page over, you'll see 50,000, correct?
Correct.
And would you agree with me that those estimates add up to 670,000? Or if you have a better
Approximately.
approximately. And is this the first time you've looked at those numbers?
I may have seen them in the business plan. Excuse me. I'm sure I've skimmed through the preliminary engineering report, but I can't say for sure if I've read it specifically on this page.
And are you aware that the company's estimate of repairs is $295,000?
Can you point me to where that is?
Well, let's just start with this. I take it you're not aware of that.
No, I know I've read it, but I want to look at it.
Do you have Mr. Cox's rebuttal testimony in front of you?
I do.
Could you turn to page 10 of that testimony?
Yes.
And at line 22 to 23, and then flipping over really just to the first part of line 1 on the next page.
And also included on the schedules JC-1C and 2C.
Correct.
I do, but I have a concern about that.
But here's
That's
my
what's stated
question.
there.
Here's my question. So obviously, you're not terribly familiar with these numbers. We've had to work our way through them pretty
No,
slowly.
I just want to verify what I'm looking at before I answer.
But your testimony says, I think, that they would be done, improvements would be done at a much lower cost by the Lake Perry Sewer or Service Company. From the evidence, it doesn't look like they'll be at a lower cost, does it?
I also am aware that there was another 7, much higher figure originally from Confluence. So I wasn't here for the testimony yesterday afternoon, so I can't speak too much to the engineering of everything. And I'm not an engineer, so.
Okay. And it sounds like you haven't really taken a detailed look at either one of these proposals for improvements, correct?
I have looked at them. I'm not saying I haven't looked at them. I have concerns regarding the water estimated cost of the numbers listed here.
But you haven't, as you said, you're not an engineer.
I am not an engineer.
You haven't looked at the facilities.
I have not looked at the facilities.
You said you had no opinion, personal opinion as to the condition of the facilities, correct?
I am under the understanding that they are in compliance.
But you haven't looked at them, correct?
No, I have not looked at them.
So you have no opinion as to whether they're in compliance or not, correct?
I guess not from looking at them, just from what I've read.
Now, in your testimony, you discussed the issue as to whether other utilities are available to provide similar service within the Port Perry service area, correct?
Can you state that one more time?
I said, in your testimony, you discuss the issue as to whether other utilities are available to provide similar service within the Port Perry service area. Is that correct?
Are you referring to where I'm discussing staff's review?
Yes.
Yes.
Would you state the page? please?
Page 10, lines 8 to 21. Actually, that may, well, where are we here? Yes. So you found that spot in your testimony?
Yes.
Okay. Now, there's currently only one utility available to provide water and sewer service in the Port Perry service area, correct? That's the Port Perry Service Company?
That's who's providing service, yes.
And so currently, there's no other utility available to provide similar service, correct?
That is who has the CCNs to provide the service. Yes, that's my understanding of
Right.
that. Yes.
If you tried to contract with someone to provide you water and sewer service, it would have to be the Port Prairie Service Company, correct?
Correct.
And you would agree that having a water and sewer system in the Port Perry service area promotes the public interest, correct?
Correct.
Yeah. So you wouldn't suggest that the public would be better off without a water and sewer system, correct?
Correct.
Now, you say that staff seems to ignore that there is another available utility to provide similar service. Is that right?
I am explaining that staff is ignoring, in my opinion, that the Lot Owners Association is also an interested party and that has intervened in this case, and that they are only looking at the applicant. They state that they look at whether other utilities are available, and the Lot Owners Association has formed the Lake Perry Service Company, so I believe that they are another option to purchase the systems to operate them. That's what I'm stating there.
But you refer to them as a utility, correct? Another available utility.
Correct.
And they're not a utility today, are they?
I'm going to object for calling for a legal conclusion. I mean, are we getting into the definition of what a utility is and whether or not?
Well, we can do it. We can do this differently, Your Honor. How about this? Does the Lake Perry Service Company own any water or sewer system assets today?
No.
And you'd agree they don't operate any today either, correct?
Correct.
Now, you also make some allegations as to why the Port Perry owners wouldn't talk to the association about a sale of the Port Perry assets and talk about them having been advised by the CSWR attorney. What attorney are you referring to?
Can you point me to the line on my testimony?
Sure.
Line 17 and 18.
Yep.
Page 10.
Page 10, line 13, 18. Hold on just a second, please. On page 13 of my testimony, I also kind of summarize it. I know there was a letter from Mr. James Beckmeyer, attorney for CSWR, sending a letter to Mr. Duwalde, ordering him to stop interfering with CSWR's contractual agreement with Port Perry.
Okay. So your reference to an attorney at that point is just to the Beckmeyer letter?
That there, yes.
Okay. And that's what you're referring to on page 10, then in line 16 to 18 as well?
I am restating what has been previously said.
So you don't have any personal knowledge beyond what's been previously said?
No, I'm just stating concerns that have been brought up in the case.
Okay. Are you aware that the Port Perry owners are represented by Mike Pendergast?
That's my understanding, yes.
Okay. And in your experience, is Mr. Pendergast shy about expressing his opinion about things?
No.
Okay. Now, moving forward, you also quote some Mr. DeWilde's statements that denial would reward citizens for their efforts by maintaining their water and sewer services within their control, correct? I think that's on page 13 of your testimony.
Are you referring to lines 11 through 14?
Yes.
I state, as Mr. DeWilde states in his rebuttal testimony, the commission will gain experience in these alternatives for making judgments in future cases, and the citizens will be rewarded for their efforts by maintaining their water and sewer services within their control.
I'm curious about your use of the phrase maintaining their control. You'd agree with me, wouldn't you, that neither the Lake Perry Lot Owners Association nor the Lake Perry Service Company own those Port Perry Service Company assets today?
They do not own those assets, no.
And the company, the entity, Port Perry Service Company, has apparently owned those assets since 1973 or so?
That's my understanding, correct?
And presumably the Port Perry Service Company has had control over those assets since 1973, correct?
Correct.
Subject to the regulation of the Public Service Commission?
Correct.
And you would agree with me, if Confluence Rivers were to purchase those assets, they would continue to be owned and operated subject to the regulation of the Public Service Commission?
Correct.
That's all the questions I have.
Thank you. Are there any questions from the bench? None here. Then I believe that will take care of the testimony for Ms. Roth. Yes. Oh, I'm sorry, redirect.
Yeah, thank you, Your Honor.
Sorry about that.
Your Honor, one point. Ms. Hernandez tells me that the preliminary report that I referenced earlier, I had referenced it as CWS 1, and apparently, I don't think there's a mark on the page, but it's CWS 2, so I apologize for that.
Mr. Kleiser?
All right. Thank you. All right, I have very little redirect, so don't worry. We were kind of, you had a conversation with Mr. Cooper just now regarding the competing cost estimates that have been put forward in the various engineering reports, and I'm going to try and make an effort here to make sure I don't say anything confidential. But just to kind of walk through the timeline here, when you were filing your surrebuttal testimony describing that the the lot owners could perform engineering cheaper, you were relying on the cost estimates in the rebuttal testimony of, I believe, Chad Sayer. Is that right?
Correct.
Okay. And then Josiah Cox filed surrebuttal testimony that had a different number.
Yes.
Okay.
I object to the characterization of that question. I don't think Mr. Sayer has any estimate. Well, never mind. I apologize, Mr. Kleiser. I should not have done that.
Is there any reason to assume that Mr. Sayer's number, or rather the estimates provided in Mr. Sayer's preliminary engineering report, would necessarily be the cost if the lot owners were to, the cost to rehab the system if the lot owners were to take control?
I think the numbers could change.
That's all. All right. There was also an extended bit of discussion regarding the bank financing, the testimony you had regarding Confluence's bank financing, and comparing that to the financing that the lot owners had talked about. And I think at some point they established that the lot owners' ultimate weighted average cost of capital, according to Mr. Justice's, was something in the nature of 7 or 8%. Do you recall that?
Yes.
Okay. And we've already established that Confluence is purchasing the system with an infusion of equity.
Correct.
In your experience dealing with water cases, is the cost of equity usually higher or lower than the cost of debt?
Usually it's higher.
Do you happen to know off the top of your head what Confluence has sought with regard to cost of equity in past cases?
I believe they've been awarded anywhere from 11 to 12% in other cases.
All right.
On ROE, on rate cases.
Thank you. And then finally, you know what, I don't even need to ask that question. I have no further questions. Thank you.
Thank you, Mr. Kleiser. Ms. Roth, you are excused.
Thank you.
And our last witness is Richard DeWilde. Please come to the witness box. Please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. Please be seated. Lake Perry lot owners, your witness.
Good morning, Mr. DeWilde.
Good morning.
Please state your name for the record.
Richard DeWilde.
And by whom are you employed?
I'm actually self-employed. I'm a certified public accountant in this Perryville, Missouri, so I'm self-employed.
And who are you here on behalf of?
The Lake Perry Lot Owners Association.
Did you prepare or cause to be prepared what has been marked as exhibit number 308 for this case?
I have.
Do you have any changes to make to that
I
testimony?
do not.
If I were to ask you those questions today, would your answers be the same?
Yes, they would.
Do you believe that the testimony, questions, and answers, as well as the schedules, are true and accurate to the best of your understanding, knowledge, and belief?
I do.
With that, I would offer Exhibit 308 into evidence and tender the witness for cross-examination.
Are there any objections to the admission of Exhibit 308?
No objections. Just a question. Was Mr. Sayers, what was his exhibit number? We had that as 308, but we may be in error. Okay.
I also have 308. 309.
We need to make this 309.
Let the record reflect, and the court reporter to please note that Richard DeWilde's rebuttal testimony being offered as an exhibit will be marked Exhibit 309. Thank you, Mr. Cooper. Are there any objections to the admission of Exhibit 309 onto the hearing record? Hearing no objections, it is so admitted. Please continue. Mr. Lynn, go ahead.
I believe I've already.
Oh, I'm sorry. You're
moved for
attending the witness.
Yep.
I got caught up making sure we were on the right number. We'll continue with our predetermined list for cross-examination. Public counsel, Mr. Kleiser, you're up.
Thank you, Your Honor. Good morning, Mr. DeWilde. Did I pronounce that correctly, by the way?
Yes, thank you. Good morning.
Do you have a copy of the rebuttal testimony of Mr. Josiah Cox in front of you?
The sir rebuttal?
Yeah.
Yes, I do.
You turn to page 6 if you find it, when you find it.
I have it.
All right, there's a table on page 6, and I am focused on the third row as it appears on that table, the first column of which reads, deemed by Missouri Department of Natural Resources to have technical, managerial, and financial ability to operate Missouri water and sewer systems. Do you see what I'm referring to?
I do.
And then in the far right column, the third column, it says neither LPLA, LOA, nor LPSC hold any permits to provide water or sewer services in the state of Missouri. Right?
That's correct.
Now, the lot owners have received authorization from MDNR to provide water services, correct?
We have.
Okay. And in that same table, in the immediate next row, organization experience in constructing, maintaining, and operating Missouri water and sewer systems. In the far right column, it says neither LPLOA nor the Lake Perry Service Company currently or in the past have owned or operated water or sewer systems, correct?
That is correct.
You do, however, have commitments from individuals who have operated systems and, in fact, have operated this system.
You are correct.
All right. Has the Lake Perry Service Company or the Lot Owners Association, I'm not sure which technically party would be responsible for this, secured the necessary financing for the $300,000 CD that was going to be used to initially fund the purchase of the Port Perry system.
Have we secured it? Is that your question? Okay, we have a commitment letter from the bank. I personally had gone to the bank to discuss whether or not we could obtain some financing to purchase this Port Perry service company. And in the conversation with the individuals that are at the home office at First State Community Bank, they mentioned to me that they would get me a commitment letter at that time that would state that if we could raise $300,000 within our organization or in our lot owners, and then use that as security on a CD or buy a CD and then use the CD as security, that they would continue with that. Now, I am aware that that's a 60-day commitment. That was at the time when we initially put that together.
And have you been able to secure commitments within your organization to fund that $300,000?
Currently, we have $252,000 worth of individuals that have agreed. I also have conversation with several others that are interested. The total amount that they're interested in contributing, I don't have the numbers yet, but I do have one other individual that is a lot owner that has mentioned whatever the shortfall is, that he will make that up.
Have you reviewed the testimony provided by the commission staff in this case?
I have.
Do you agree that commission staff have carefully considered the proposal to purchase this system that has been made by the Lake Perry Lot Owners Association?
I do not believe they gave careful consideration to our proposal. I do know that we do not have a signed contract. I'm aware of that, but I do believe we're a viable option, and I do not believe that they've taken that seriously.
You just mentioned the not having a signed contract. I believe in the testimony of, sorry, hang on one moment. Do you have an understanding of why, or do you have an opinion as to why there is not a signed contract at this point?
I do have an opinion. I know Michael Yemnitz very, very well, and we've had discussions at various times on different items. He had come to me to let me know that there was a signed contract on this, and at the time I mentioned that, we may be interested in purchasing also, and he acted as though that would be great. Then he came back later and said, I'm sorry, I cannot talk to you. I've been told that I'm not able to discuss anything with you, that I have a signed contract, therefore I'm not willing to sign anything at that point. So basically those are the facts. We did send an asset purchase agreement to him, asking for him to sign. The asset purchase agreement basically says if the commission does not allow Confluence to go through with this process, that we would be an alternative to that and we'd be interested in purchasing.
Thank you. Were you given a reason for why Mr. Yemnitz would no longer speak to you regarding the proposed sale?
His reason was that his attorney told him not to talk to us about this.
And do you know who that attorney was?
I do not. I did ask him if he would please let me know who that attorney was, if he didn't mind. And he hesitated a second, and then he said, yes, our attorney is the same attorney as Confluence. And that was what he had mentioned to me.
All right. Anything else? All right, one last thing. This is a bit of a weird question. I just noticed that you're wearing a nice red tie, and I think it's the second time in a row I've seen it in there. Is there a reason for that?
Yes, we tried to show some sort of, I don't know what the word is exactly, but cohesion among all the people at the lake. We have a number of people here, lot owners from the lake that have come, and they're wearing red. At our public hearing, we wore red. It just is something to kind of show that we are all in this together, and so that's what the red is all about.
I have no further questions. Thank you.
Thank you, Mr. Kleiser. Staff?
Thank you. Good morning, Mr. DeWilde.
Good morning.
Could you please, well, first of all, you said that you received a permit from the Missouri Department of Natural Resources.
Yes, ma'am.
What did you have to do to get that authorization?
Our attorney had filed with them and gotten the authorization, so actually I can defer to him that it came through his office.
Do you know what was filed?
I think I have a copy of it. If I can look here a second. Bear with me here a little.
Sure.
Yes, it's a letter from Missouri Department of Natural Resources, signed by a Chris Weberg, dated March 20th of 2019.
You're looking at Schedule RD6?
Yes, ma'am.
Okay. Could you read, or start reading at least, the middle paragraph of that letter?
I will. The department has reviewed Lake Perry Service Company's articles of incorporation and bylaws and finds they meet the requirements set in Section 393.825 to 393.861 for nonprofit sewer companies and the requirements set forth in Section 393.900 to 393.951 for nonprofit water companies. Should I continue?
That's fine. So from that sentence, does it sound like your attorney only submitted Lake Perry Service Company's articles of incorporation and bylaws in order to get this letter?
I can only assume that you're correct on that.
That's not a very onerous thing to do, is it?
I don't know the technicality of all that, so I can't give you an answer on that.
So the lot owners have certification from the Missouri Department of Natural Resources to operate a utility. Isn't that correct?
Yes.
But they have no permit to operate the utility.
No, we do not.
You told Mr. Kleiser that the lot owners do not have a signed contract with the sellers to purchase the utilities.
That is a correct statement.
Have the lot owners filed an application for a CCN for those utilities?
I don't know the answer to that, ma'am. I don't know.
Application or purchase. Have you, are you aware whether the lot owners have made an application to get permission to purchase the utilities?
Again, I would defer to the attorney. I don't know the answer to that.
Okay. I'm curious about the commitments that you were discussing with Mr. Kleiser for the initial cash.
Yes.
So the lot owners have no cash in the bank, so to speak?
They
right?
do not.
Could you please turn to Schedule RD3C in your testimony?
I would just like to interject that this is marked confidential and it does include people's names and amounts.
You just told Mr. Kleiser that so far you have commitments of $252,000 to
Yes, ma'am.
purchase the system. And this letter, Schedule RD3C, it's dated as of July 8th, 2019, that you had $252,000.
Yes, ma'am.
And then you wrote in your testimony that there was $252,000 committed.
Yes.
How long has that balance been there?
Continually since that date that you've seen, I've not pursued additional financing or extra money since that date, so that's not changed.
The July 8th date?
Yes.
Okay. And you told Mr. Kleiser that you expect a person to come through with the shortfall if there is a shortfall?
That is correct.
So the shortfall is almost $50,000?
Yes.
And I'm not going to speak to the actual commitments or the people, but looking at your Schedule RD3C, wouldn't you say that there's quite a range in the amount of the commitments?
I would say there's a very big range, yes, ma'am.
And if this person follows through with that final payment, that would be the largest commitment of all, isn't it?
No, it would not be.
Oh, not quite, not quite. But it would be in the top.
Yes, ma'am.
What does it mean for this project to have made a commitment to it, a financial commitment?
Well, basically what it means is that our lot owners are very committed to what they want to do, and doing that, they put their money where their mouth is. We've told them that we're going to need some sort of a way to finance this. To go straight to a bank and ask them for a loan when you have no prior history is virtually impossible. You're not going to get money. So the hope is, and what we discussed with the bank is, that we would have a track record of 3 years to develop a plan for them to show that we'd be profitable and could move forward, and at that time, then actually try to secure commercial financing.
So these people that have made the commitments, are they obligated to contribute the money if this project comes to fruition?
Yes, ma'am.
So what is binding upon them to contribute the money?
You know, there's no real binding. We don't have a commitment letter. We don't have anything signed. We work off of trust, and we have a lot of trust in our individuals out there and our lot owners. I suspect that maybe one or two of these might have some other things happen in their life that would preclude them from contributing to this, but yet I would have others that would step up once they know that this is going. As I said, I have other names at my office that have said, you know, once this goes through, let me know. I'll be more than willing to commit. I don't have the numbers. I don't have anything, but I do trust that when these people say they're going to do it, that it will happen.
So are there any sanctions if a person changes their mind and decides not to contribute?
Oh, no.
Is anybody going to enforce this commitment?
In what sense do you mean enforcement?
Well, I mean, there's no contract to follow through with the commitment, is there?
No, we'll have a note between us and them that will actually have an interest-bearing amount so that we can pay them their interest on a quarterly basis, which is what we plan on doing. And therefore, and like any other note, you know, it's set up to where we'll pay them off after that 3-year period.
But there's no penalty, and there's not going to be any enforcement if some of these people decide they don't want to contribute?
Oh, no.
Okay, thank you. I have nothing else.
Thank you. And Confluence Rivers.
Thank you, Your Honor. Sir, I think your testimony says you're president of the Lake Perry Lot Owners Association, correct?
I am, sir. Thank you.
And I see also from your testimony that Lake Perry Lot Owners Association bills lot owners for an annual assessment. Is that correct?
That is correct.
Yeah, I think your testimony says that the annual assessments are transferred to the Perry County Land Company, correct?
That is correct.
Okay. And an annual assessment for the Lot Owners Association total for a year, $440,000 or so?
Not quite that much, 380,000 maybe. Some years we have larger sales of lots and stuff, which increases our amount, but assessments alone is probably more like 380.
So your financial statements might show a greater amount, but that would be more than just the assessments. It would be also some lot sales. Is that what you're saying?
Yeah, we have lot sales. We also have marina rentals. We have some other things that generate additional income.
Okay. In your financial statements, I see an amount for rent. Is that what's turned over to the Perry County Land Company?
It is. It's a transfer from one corporation to the other.
And as of April this year, I think you were still the president. You were the president of Perry County Land Company. Is that correct?
Yes,
And are you still the president of Perry County Land Company?
I am.
Okay. And Perry County Land Company is a general business for-profit company, correct?
It is.
And are you a shareholder in that company?
I am not.
Who are the shareholders in that?
The shareholders of the Perry County Land Company are actually the lot owners themselves, so there is no individual shareholder.
Now, you mentioned earlier, a certified public accountant, correct?
Yes, sir.
And you currently perform work for the Lot Owners Association
I do.
in the capacity of a CPA?
Yes, and also manage the operation from our office.
And do you do that work for Perry County Land Company as well?
I do.
And I suppose it looks like from your proposal that you would also do that work for Lake Perry Service Company, correct?
Yes, to get it started, that would be the plan.
And you've been paid for your work on this intervention as well, haven't you?
I have.
And that amount would be tell me what that amount is as of today.
17, 18,000, somewhere in that neighborhood.
I think in your responses maybe to Mr. Kleiser's questions, but I could be wrong about this, but I think that you pointed out that the commitment letter that has been referred to in this case for the $300,000 had a 60-day fuse on it, correct?
It did.
And do you remember what that letter was dated?
Can I check?
Certainly.
I believe it was in May of 2019, but I don't know the exact date, sir.
I think it's, if it helps, it's Schedule RD2C.
RD2C, thank you. Yes, May 3rd of 2019.
So the 60 days would have run early July, correct?
Yes.
Now, there'd been some discussion about the issue of local control over these water and sewer assets, correct?
Yes.
And those are the assets that are owned by Port Perry Service Company, correct?
Yes.
Are you familiar with Missouri American Water Company?
Vaguely. I'm not highly familiar with them, no.
That's kind of two things. Let's start with that. Vaguely, what's your familiarity?
I know who they are, but I don't know a lot about their operation.
Okay. But let me ask you this. If Missouri American Water Company would purchase the Port Perry Service Company assets, would you have the same concern about loss of local control?
I think we would have to evaluate that at the time that would potentially occur.
If I were to tell you that their parent company is based in New Jersey, would you still have the same concern about local control over the water and sewer?
I think
assets?
my answer is the same. I think we would have to look at that at the time and see how we would evaluate that.
How about Are you familiar with an entity called Liberty Utilities?
I am not.
Okay. Will the Lake Perry Service Company owe the Lot Owners Association for the costs that the association has expended in this intervention?
They will.
And I take it from your DR responses that you don't know how much those costs will eventually be, do you?
That's correct. It's still ongoing.
But in terms of just yourself, experience on demand, and Allstate consultants, the number is greater than $50,000, correct?
You are correct.
And that doesn't include whatever you might spend for Mr. Linton, correct?
You're correct.
Okay. And I take it from your response, there's no ultimate budget, there's no top end to what might be expended, is that correct?
That is correct.
Now, the association, the Lot Owners Association, it doesn't own the Lake Perry Service Company, does it?
It does not.
And today, the Lake Perry Service Company has no members, correct?
That's correct.
And I think we talked about it a little bit, the Lake Perry Service Company doesn't own any water or sewer system assets today, correct?
Correct.
And has no permits to operate water or sewer.
Correct.
And again, doesn't have a contract to purchase any water or sewer assets as of today, does it?
Correct.
That's all the questions I have.
Thank you, Mr. Cooper. Any questions from the bench? I don't have any. Redirect from Mr. Linton.
Yes, Your Honor. Just one question, Mr. DeWilde. You had a question from Staff Counsel Bretz regarding your schedule RD6.
Yes.
Would you go on and read that last sentence of that middle paragraph?
I will. The department hereby authorizes Lake Perry Service Company to provide sewer and water services within the service area defined in Exhibit A of the Articles of Incorporation.
So you would agree that you do have the authorization of the Missouri Department of Natural Resources to provide water and sewer services in that service area, correct?
I do.
No further questions.
Thank you. Mr. DeWilde, you are excused. That concludes all of our witnesses for this case. Are there any final matters? I'll ask that one more time before we officially close our hearing.
Yes, Your Honor. There was a discussion about professional engineers' registration seals. I would just request that the Commission take administrative notice of 20 CSR 2030-3.010 and 3.060. Those are the rules of the Department of Insurance, Financial Institutions, and Professional Registration.
Are there any objections? The Commission will so take administrative notice.
Thank you, Your Honor.
Counsel, are all of your exhibits entered?
Yes.
Just for your own references. Initial briefs are due October 24th.
Your Honor,
Yes.
I was going to ask for a one-week extension to both briefs. I attempted to communicate this with all of council. Some have not gotten back to me. But I would like to make the request for a one-week extension to both briefs.
Can you find the exact dates that you want while I ask the other council if they have an objection to your request?
Your Honor, if I'm one of the council that hasn't gotten back to Mr. Kleiser yet. If we could have a few minutes just to talk about this off the record, we may be able to clear it up.
Let's go ahead and take
Well, how about this? Yeah, 'cause I don't really want you to have to go off the record and come back on. But
Yeah, we're within
would it be
2
possible
minutes.
for us to get together and talk and file today what we're going to do with the extension? Or
I like that. Perfect answer.
All right.
Okay, right now, the initial briefs are due October 24th. Reply briefs are due October 31st by 10 a.m. Whatever date you all agree to, please keep that 10 a.m. or noon, because I still need to write for the commissioners before their next agenda meeting.
So is that just for the reply brief that it's due by 10 a.m.?
Just the very final one.
Okay.
The reply briefs. Just make that sometime before 3 in the afternoon. So we're all attorneys, and I assume that means 2:59. That's fine. Last call. Any other matters before I adjourn? Hearing none, we are adjourned. We're off the record.
So they're going to submit something in that.
yeah, no.
Yeah, I talked to her.